for restitution. So companies like Publix or Walmart could waive that in the future. And so hopefully the state's attorney is working on that or maybe asking that question as well, and something you all can work on with those major firms.
So you mentioned the Rocket docket, and this relates directly to the fines and fees and restitution that's owed. And what we want to make sure when we're fulfilling the voters' will about implementing Amendment 4 is making sure we're doing it in a way that doesn't create two classes of voters. People who can afford the right to vote and people who can't. That's not the law intends, it's not constitutional, it's not fair, and I'm telling you it's not going to happen here in Hillsborough County. Because what we're doing is making sure that for those outstanding court costs, which can start at a couple $100 and then skyrocket over time with late fees and administrative expenses, we're setting up this docket with the help of Public Defender's Office, the Supervisor of Elections, the Clerk of the Court, too many agencies to name, to go into the courts, to convert those court costs to community service. Now the community gets a benefit because those monies were never going to be paid. Now the community gets a benefit by the person completing community service, and more importantly, they'll have earned the right to vote back exactly as Amendment 4 promised.
Any other answers? Good afternoon, Michelle Lambo. My question is for Mr. Warren. Accountability was mentioned earlier in criminal justice reform, and Florida statute 918.13 makes it a third-degree felony for any person knowing that an investigation is pending or about to be pending to alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its rarity or availability. So why did the Office of the State Attorney, 13th Judicial Circuit, decide not to prosecute the disgraced, fired ex-officers Landry Larada and Alginus Maceo for tampering with physical evidence? And those three officers were known to patrol East Tampa. That was their primary area.
So the case that you're referring to, Michelle, is the case of 3 officers fired from TPD for essentially not documenting evidence. Now, this was investigated by TPD. And from the time we learned about it, we had our conviction review unit, that specialized unit to identify and review and fix wrongful convictions, look into that. And what we ended up doing was unprecedented. Not only did we dismiss cases that were pending where we had to rely on those officers' testimony, officers who had been discredited, we went back to closed cases. And we ended up vacating, or in the process, going through the courts now to vacate 17 convictions that were in closed cases. Never before happened in Hillsborough County. This is exactly what we should be doing in the criminal justice system. When we have a conviction where we don't have faith and confidence in the integrity of the conviction, going back and looking at them, that's exactly what we did. You mentioned about prosecuting the officers. The investigation that was conducted by TPD didn't come to evidence that we could have prosecuted them for. But what we were looking at was the convictions that we had already secured to do everything we could, even if the people in those cases were not truly innocent, that is factually innocent, they were procedurally innocent because the process didn't live up to the standards that we require.
Hi, Chaminda Murphy, member. My question is, as we work on much needed criminal justice reform, how do we ensure that we don't inadvertently send a message that minimizes the trauma and terror that some victims of crime experience, specifically survivors of domestic violence, because there's often substance misuse allegations, there's often mental health allegations, and sometimes that obscures the fact that domestic violence is a choice made by one person to terrorize and traumatize another person. I am concerned that second chances may reinforce the societal ways in which we often minimize what happens in DV.
I'll take this one again first. Mindy, it's a great question. I mean, the reality is that domestic violence is so hard to prosecute sometimes. Across the country, we have low success rates, we have high declination rates. We have a new supervisor that we put into our DV unit to put everything under the microscope. I've been asking colleagues around the country, how can we do a better job at doing this? How can we do better blocking and tackling in terms of prosecuting DV cases when we know the likelihood that when we're unable to make a case, there's such a high rate of recidivism And we are just fearing that day when not only that crime is committed again by the same person against the same victim, but God forbid it ends up in a domestic violence homicide, which we have far too many of in Ellsworth County. We worked with the Spring and so many other organizations on our Disarming Domestic Abusers initiative to take guns out of the hands of domestic abusers for all the benefits that that has, protecting the survivors, protecting law enforcement, giving us extra leverage against the abusers. We know that's marginal differences, making a marginal difference. I wish there was that perfect silver bullet solution, but we need to keep doing everything we can to prosecute abusers and protect survivors.
Joyce Hampton-Henry, ACLU reporter. Senator Brandes mentioned the criminal punishment code is the single greatest reason for over-incarceration in Florida. What is the legislator's appetite for reviewing or getting rid of the code? Is there any chance of amending the code soon? For everyone else, what are your thoughts and opinions about the code?
Wow. So perfect timing for this answer. So just yesterday, we finally seated all of the members of the Criminal Punishment Review Commission. So if you look at the major legislation that passed this year, a portion of that was that the Attorney General shall establish a Criminal Punishment Code Review Commission. It hasn't been done in decades. That looks across the board and will spend the next, frankly, year working through the Criminal Punishment Code to look at the best practices, to look at where the discrepancies are, to try to figure out why are you much more likely to go to prison in Bay County than you are in Miami-Dade for the exact same crime. And what are the opportunities to really look at the best practices from around the country. So that will kick off in August 15th, and it will probably meet every month up until next June. I hope the ACLU will be involved.
Any other answers?
Hi, Tom Scherberger, board member, and I work at the clerk's office. And as you know, the court system is financed on the backs of people who use the system. And now many of those people, most people didn't realize that 90% or more of fines and fees are never paid. Now that's a hurdle to voting. What can be done in the big picture here to deal with the fact that you are using these folks to pay for a court system they can't afford? And the court system is underfunded.
Yeah, so also we have right now a study going on fines and fees because we know it's a major problem. Back in 2008, 2009, when the state was running a deficit in so many areas, they jacked up the fees, as you know, on traffic citations. Well, what was the effect? We've seen a radical reduction in traffic citations because when a law enforcement officer comes up to a mom with 2 kids in the back of the car, driving an '84 Toyota Corolla, and he's got a $300 ticket he's about to hand her, he all of a sudden writes her a warning. That is just human nature. We need to review top to bottom how the criminal justice system is funded. A lot of the things that State Attorney Warren wants to do as far as the rocket docket and waiving fines and fees, the struggle is many of them are statutory, right? You're not going to waive money into the Justice Compensation Trust Fund, right? And the perverse incentive that may come from some of these things when all of a sudden local jurisdictions are saying, we need resources. And then the question is, well, you just waived a bunch. So what happens here? So I think the real question is, how do we have a system that works? What are the best practices in the fines and fee space that ultimately will work, that produce the best outcome for justice, for the victims, and for the system overall?
Anybody else?
Oh,
We'll cut you off, Andrew.
it was bound to happen. Tom, it's a great question and actually touches on bigger issues than just about the fines and fees. This is about the criminalization of poverty. The simple reality is that if you live in a low-income neighborhood, you're more likely to end up in the criminal justice system. If you grow up without access to high-quality education, you're more likely to end up in the criminal justice system. If you don't have a strong family support network around you, you're more likely to end up in the criminal justice system. These are macro issues we have to address in the system, and they take the form of the fines and fees that get piled upon people, including civil fines and fees that translate into criminal violations like driving with a suspended license. it takes an effect in the form of bail and the need for bail reform. Why are we locking up people solely on an inability to make bond when they're not a threat to the community? There are so many issues here to address, and to go back to the senator's point, there's no single policy to do this. We have to take this comprehensive approach about what we want our system to be, who we want to put in jail, how we want to fund it, and how we want to support people who we don't want to be incarcerating, but rather to problem solve the reason why they came into the system in the first place.
Thank you.
Good afternoon. My name is Townsend. I'm a member. Senator Brandes, I appreciate your individuality. I love your socks. I'm assuming that was not an accident. But I'm going to start to ask you to respond to this first and then ask the rest of the panel. So when Ms. Fry asked what was the single thing that you, the second question that you asked, your response was, I think we need to separate those people that we're afraid of and those that we're mad at. Well, in this day and age of othering, and in particular, if you don't look like me, if you were not born in America, if you don't practice the same religion as I do, I should be afraid of you. So I'm wondering if you drill down on your response to that and ask, and also the rest of the panel, how do you differentiate somebody that I might be falsely afraid of because of some of the rhetoric that's going on in the media?
Yeah, so let me explore that. So I think the first question you have to ask in any conversation that deals with prison, like in what we want your prisons to look like, is who do you want in jail? And I would argue that the best people to put in jail are the people that you're really scared of. Murderers, rapists, people that clearly are committing crimes over and over again, that are of a heinous nature, that are truly people that we're scared of. The people that we're mad at, drug addicts, right? People that are that have theft, these types of things that are we're mad at them, but truly not maybe scared of them, right? They're harming themselves. They're minor property, these types of things that need to be addressed because they have some family situation. That's really what I'm talking about, right? How do we make sure that we're focusing our limited resources of the prison system that are frankly stretched beyond the breaking point today on truly the people that truly need to be in prison? Because many of these people are not getting better in prison, right? When you take somebody with a severe mental health issue and you lock them in prison, in a cell, by themselves for days on end, that is a recipe for disaster. Same with people who are simply suffering from addiction. They join gangs, they have to earn for those gangs, that there is all kinds of problems in the justice in the prison system today. So let's start with talking about who truly needs to be in prison and who the society wants to be in prison.
Any other answers up there? We've got time for a few more questions here. Okay. Got three. 1, 2, and 3.
Good afternoon, Haiti Oropesa, and I want to thank Ms. Holt for being one of the first public defenders in the state to implement ESAFs in order to combat disparity in sentencing, including disparity based on race. So thank you. Thank you also for now having a new practice of requiring or asking the state attorney for Brady and Giglio material. But I'd like to ask you, Mr. Warren, what mechanisms do you have internally in your office to make sure that, because giving over to the defense Brady material and Giglio is actually an obligation of the state attorney's office. So what mechanism does your office have to make sure that that does not fall through the cracks, that any of your assistants willfully or unintentionally fail to give that information to defendants?
So for the non-criminal attorneys in the room, Brady and Giglio refers to basically exculpatory information or information that you can use to impeach a witness. And as Haiti pointed out, it's the state's obligation or the government's obligation in a federal case to actually turn that over even before being asked. So what protections do we have in place? Training, training, training. We have to retrain our prosecutors to make sure that they understand the obligations of Brady and Giglio. I tell every new prosecutor in the office, they're one of 3 ways to get on my bad list. That's not what I call it, but one of them is playing games with the discovery. We don't play games with the discovery because it always comes back to bite us and it's the wrong thing to do. But I'll admit, in 70,000 cases a year that come through our office, there are mistakes that get made. There are times where we don't turn it over, and when we see it happen, we go right back to that prosecutor to establish why it happened, whether it was intentional, whether it was a poor judgment decision, or whether it simply was an omission. But that's how we're addressing it. And by lots of communication with the public defender's office.
Thank you.
Mickey Castor, and I have a political question for Senator Brandes, and although you're not on the panel, for Senator Rousseau. Your positions are obviously, from our reaction, what we are looking for in our state leaders. But my question is, are there enough who have this approach to criminal justice in the legislature to get the changes in the statutes that we need to implement all these wonderful programs we want to do?
So great question. I think I always tell people you need two things to be successful in the public policy space. You need a vision and you need a champion, right? And so I think it's up to us to cast a vision, and up to you all to cast a vision for where we want the criminal justice system to go. And then it's up to you, us, to either make or elect champions of public policy in this area. And I think that's what you're starting to see in Tallahassee is, I stood up, Senator Rousseau has stood up for years on driver's license, on civil citations, on felony theft, on a variety of areas of public policy. And you know what? It's starting to break through. People are starting to hear us. And you're starting to get more and more members whispering, look, I'm with you on this. And it's fun because, it used to be we would stand alone at the press conferences. And now people are saying, well, you're having a press conference. Can I come? Can I stand with you? And join in that conversation. So I think you need, as every movement, it starts with a vision of somebody who's bold and willing to say, here's where I want to go, and finding the right champions to take us there.
Thank you. Our last question from the audience here.
Hi, James Shaw with the ACLU of Florida. My question's about bail reform. The bail reform movement has done a great job recently of highlighting anecdotal cases of people who couldn't come up with $250 and spent weeks in jail. You can lose your job, you can lose your apartment, you can lose custody of your kids. A lot of horrible things can happen to you, and also you can feel pressured to plead guilty just to get out. One of the cases that was in the newspaper last month was about a guy who couldn't come up with $250. He was in jail for 13 days. Tell me what that tells me, that ability to pay is not being considered. Tell me what efforts can be taken to ensure that low-level nonviolent offenders are not held hostage to a guilty plea or have their inability to pay not considered in setting bail.
Thank you.
I'll start. I think the innovations are really occurring in the circuit levels. So if you go over to the 6th with Sheriff Galtieri, he's got a very strong program of electronic monitoring for certain individuals and allowing them to either have a discounted or no bail with that, or RORing them, just releasing on their own recognizance. So I think I think it's partially at the state level, but I think it's also so much can be done at the local level with best practices. The purpose of bail is really to make sure that people show up for trial. That's the entire purpose. So it's not, what are we making sure that we're following the best practices and ensuring that people that cannot pay can have a pathway so that we ensure that, again, they show up for trial. Bail is not appropriate for everybody. It's appropriate for some. It has been a successful tool. It is a successful tool for some. And we need to use it where it's the right tool for the right job.
So here in Hillsborough County, we have what's called a standard bond schedule. And as you know, we have 50 some odd different judges. Many of them sit in a place other than criminal, and they sit in civil. And what I've observed is from the civil judges, you have a very difficult time in convincing them to deviate at all from the standard bond schedule. Criminal judges are a little bit better informed as it relates to cases and levels of proof and things like that, and they're more likely to really look at setting a reasonable bond. Recently, a couple of things. I think both Mr. Warren and myself and the sheriff have indicated that perhaps we should revisit this idea of having a rotating first appearance judge and instead put judges in there that have criminal experience. I think we all agree that we should revisit the bond schedule that's in existence at this time and make it more realistic because it's been about 20 years. And then the third thing was another phone call that I made to Mr. Warren probably about a month ago saying, here are all the cases And the types of cases, nonviolent, first-time misdemeanor offenses, and we're gonna start asking judges